Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Sabi mihi Anglican for each service.
Is that correct?
Literally not true. Oh, for Trump's sake. I didn't ask you to interrupt me.
Alrighty. Good morning. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for joining us this morning. Happy Tuesday to you. Happy Tuesday. We're not going to miss anything. I promise. We're, thought I was going to show you something, but I didn't get it ready. So hold tight. This one right down here. Over here. We're not missing anything. People are just filing into court right now, so we've got a bit before it starts. Six, 2 is not used, 3 is 2, and 4 is media player 1. Is that right?
I was kicked back, taking it easy.
4 is MP2. There we go. Sorry, I've got to build this in my head again. 1 is 6.
I saw a chicken fight.
When are we going to break for lunch, Judge?
The zombie apocalypse may be upon us.
And everything working.
Because he's the guy.
Tie that. Oh, that's not it.
Scratch all that. Oh, that was terrible.
All right, now we're ready. Whew. Now I can finally show you that court is going to begin. Jen D, good morning. Welcome. Jen, you were first in chat this morning. Congratulations.
More experience.
We'll come back to court when something
If they
happens.
didn't, I would lose my mind.
I would lose my mind. Oh, my goodness. Chat is going like crazy this morning. Absolutely crazy.
I think I'm about to catch a whooping.
I'm about to catch a whooping. All right. Let's see. Wow. It is good to be here. Jen D, it's good that you were here first. Who's that lurking outside the window? Was that the witness from the other day? That's her.
Somebody just
She has absolutely luscious hair.
Fighting.
Is that? Did you guys notice that?
How does he do that?
Like, I'm not sure if luscious is the right word. Like, luscious was not the right word. Let me take that back. She has, like, her hair's pretty. Did I say that right? Yeah, now I'm in Yes, beautiful and shiny. That works, Court. That works.
The zombie apocalypse may be upon us.
All the sounds are happening right now. Let's see. Ashley's like, we didn't notice it at all, RA. What are you talking about? Jen D, you were first in chat. Sorry, let me finish this. We're sentencing you with international ownership. That means to reward you or punish you, as the case may be, for being first. You own the internet, and everything connected to it is your responsibility today. There's really no financial incentive. Really, it's just a work. It's just extra work on you. So whatever you had today, hopefully you can just set that aside and focus on everybody else's problems on the internet, because we'll be calling you to have them fixed. Thank you so much. I think you're going to do a great job with it, by the way. And make sure you've got an internet ownership certificate to commemorate this amazing win, suitable for framing or use as a cover sheet on your CV.
About to catch a whooping.
We have to sing here pretty quick.
I saw a chicken fight.
She talked her good hair too, Maisel. That is hilarious. I'm going to turn the sounds down just a little bit. We need to sing birthdays pretty quick because, man, I apparently I was a couple minutes late. A couple minutes. Sharon sends the buffer sound right there. And look, we have Trial Watcher, Delaney, and Amy all celebrating their special day, which means we need to sing. Hope you guys are warmed up, dancers. I hope you're stretched. You're ready. You've practiced the routine, because here we go. Join with me in singing to Trial Watcher, Delaney, and Amy. We do that first by warming up together. Everyone, deep breath. La 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 la. Beautiful. We're ready. We're ready. Okay, shoulders back, deep breath. Project your voice to the back of the room. Blend your voice with those of your neighbors. We're going to sing happy birthday to these three wonderful people. Happy birthday to you. Happy birthday to you. Happy birthday, Trail Watcher Delaney and Amy. Happy birthday to you. Balloons galore, says Kaylee. The balloon drop from the ceiling was a nice touch. Did you arrange that, Kaylee? It looked fabulous. I can hear the sound of them popping all over the room. It's beautiful. Whoa, whoa, whoa. Lady J, it's my birthday too. Happy birthday to you. Happy birthday to you. Happy birthday, Lady J. Happy birthday to you. One more verse. Happy birthday to you. Happy birthday to you. Happy birthday, dear Carrie. Happy birthday to you. We're running out of late opportunities to sing happy birthday, but we fit a couple more in there. Lady J, Carrie. We had, where's the first ones? I'm looking. Trial Watcher, Delaney, and Amy. So five birthdays to everyone who's having their birthday today. Have a wonderful, wonderful birthday. Hopefully, as you celebrate your birthday, it includes free pancakes at whatever establishment honors that time-honored tradition. Or I should say participates in that time-honored tradition. Denny's, IHOP, maybe. I don't know. It's worth a shot. Let's see. We're gonna wrap up the birthday song. The party doesn't stop. Celebrate all week long. I'm gonna do it all week long. You get the next 4 days to party. So have a wonderful birthday. Luscious is a great word. Yes, but it's probably not a word I should use to describe another woman's hair other than my wife's. So I take that back. Okay, last verse. We're going to do a big drum solo, and then we're going to start talking about court. Here we go. Get your drumsticks out. Ready? I've got mine. Ready? There we go. Beautiful, beautiful drum solo to end everything. As we go back to court, where are we? We're looking at the door. You guys did a great job with the birthday song this morning. Thank you very much. I appreciate all of you singing. The idea that we have, I like to think thousands, but hundreds is probably more accurate. Hundreds of people singing all over the world to celebrate someone else's birthday. I think that just spreads cheer in everybody's heart. It's like if you wake up, like trying to do something good for somebody else that day. How in the world can you have a bad day if that's the first thing you do in the morning? So that it makes my day. I'm glad it makes yours as well for those that have a birthday. Congratulations. All right, where are we at today? Oh my goodness, the state has rested. The defense has rested. We now are beginning. We have closing arguments today. Ooh, lots of people coming in. Younger crowd that we normally see in court. That's interesting. Now they go straight to the defense side of the room. Josh, I cannot say much, and I cannot say enough about luxurious is the word you wanted. That was it. Luxurious. Luscious just sounded like I was like smelling it or something, and I was not, nor do I want to. Just for the record, I'm sorry, I'm in trouble already. Josh, you guys were absolutely amazing. Thank you for helping us out in such a huge way. We're putting together the new switcher order and limping through with what we have. We've rerouted a bunch of audio. We also have another intermittent problem which I hope doesn't pop up before we can replace this again. But sometimes the switcher says that it's showing one thing and it won't show that. It's showing something else. So it's definitely got to go. I have been up reading forums and trying to find fixes and workarounds, and this is what we have. I think we can make it fairly seamless for now. I'm just not going to be using a lot of the other features that we normally have. So, but thank you for your generosity. We are just over the moon, and from all of us here. From all of the RA family, thank you very much. All right, no jurors should come in this way. This is the public entrance. Jurors come in another door. All right, is there anything else we need to go over before closings? Ashley is facing 2 charges. First, murder 2, and what is it, aggravated manslaughter or something? I think that was, those are the 2. Can the state recall Eva? This decision is going to be made today, I think. Well, actually, it was made last night. Yes, they can recall her. They have some limitations on what they can ask. They cannot get too much into, see, like the picture the judge cut yesterday. He took the scissors out and just cut the evidence picture up the middle and said, "I'm taking this half. You can keep the other one." That picture specifically in the questioning, they have to be very careful not to ask questions that would elicit an over emotional response, or like, "This was the last picture I took of my last time we went out on a boat with my dad," type thing. That would be too prejudicial, and that will not be allowed in. But that's not because of her social media posts or the interview she did mid-trial with a reporter. Do you guys have an echo? Let me check. Test 1 2. Check. Test 1 2. I do not have an echo. Test 1 2. Is that better? No echo there. Okay. Oh, good. More people with no echo means it may be on your side, Detect Vids. I'm just saying you might have two feeds running. If you have a computer, you might have two windows open with the same video, which is twice the fun. Oh, sure. Both lawyers are so incredibly careful. There will be some objections, I think, for sure. Speaking of lawyers, there's one. There will definitely be some objections and some spiciness. There will be, I believe, only one witness is being called in rebuttal, and that's Eva. The question that
I think I'm about to catch a whooping.
The question that they're asking about right hand, left handed, I believe that came from chat. I'm not sure if it was our chat or another chat, but we know that the sides do watch. They watch online. They watch communities that watch the trial and look at feedback and questions and input and suggestions that come in chat. We know that, and I think the question they asked that they're going to ask Eva today about if her dad was right or left-handed came from that. That's one of those just little deep insight things that I thought I would share with you. That's just my personal take. Ricky C says, "Wow, 12 months." Oh, Ricky, 12 months, whole year. Glad to be here. Thank you, RA and mods, for everything you do and don't do. I love that, the do and don't you do. That's a little. It's one of those things where, like when we say hell chat, it's because somebody made a typo a long time ago. I don't even know who did it. They were just excited to be there, and they're just saying hello to everybody, and they missed the O. And it was just the funniest thing. And we laughed with them, and so people tell chat hell all the time. So I love those little inside jokes. All right, bring on the spice, says Tinkerloo. We're ready for the spice. Bailiffs are getting ready for court. Lots of in and outs right now. They were expected to have a 9 o'clock start. They were supposed to be here for 8:45 for a start, and it looks like we're just a couple minutes behind. But any moment now, we'll get that ear-splitting noise from court, letting us know. I'm at least seeing an audio level, which is good. So letting us know that. You know what? Why is it missing that way? It removed my paper shuffling filter. I guess that's one of the things that just doesn't work. It's no bueno. Well, we'll live with papers, I guess, today. I feel the prosecutor's overconfident. She dropped the ball on this one. I've put so much thought into this, and man, of all the cases, and we've had some difficult cases to watch and to deliberate on as potential jurors, but this is a tough one. This is a really tough one for me. Yeah. Picky says, "I was unable to be here yesterday. What did I miss?" just one of the most amazing displays of love that I've ever seen. Chat was absolutely incredible. The court was spicy as well. Court was interesting. A lot of fun things happening. Good testimony. I would say of all the testimony that came in, I think that was most. Let's see. I didn't write down what Dr. Lou, the hair, Dr. Good Hair 2, I think we could call her. What was her final conclusion? I forgot to keep that in my notes. I'll have to rack my brain to think. Michael Haig, the long-winded bullet expert, loved seeing him, the son version of the father that we saw in the Rust trial. Detective Justin Warren, the hostile witness, but whose testimony got cut short because he was only called for impeachment purposes. Oh, Lou's finding. Oh, yes, Lou did the bullet trajectory, right? She did the demo with the law clerk, the poor law clerk who thought he was going to law school to, research cases and one day become a lawyer and make fine arguments in front of the court. Instead, finds himself on his back with his feet up in the air, with his butt facing the jury, and a doctor poking him with a stick. You can't make up these things. Truth is stranger than fiction. This poor law clerk got dragged in as a model for a shooting recreation. Let's see. Was that really the Haig son? Yes, it was. Yes, it was. The father and son, they're the same. They're a team. Donnie, how are you doing? Good talking to you the other day. Welcome. Thank you. There's the defense team. Okay, defense team's here. We should be able to start now. They're late. They're 5 minutes late. And it looks like they were in a meeting. Because they all came in together. I'm pretty sure they don't carpool. All we need is a stick figure drawing of the demonstration on the whiteboard. Oh, that would be great. The best stick figure drawing, Lego My Briefs, I think this is what you're referencing, was the ski crash trial up in Park City, which was, I believe, the same court, maybe even the same courtroom that we're going to be in for Corey Richins. Ooh, Judge is here. He has that look like he's been here for a while. This is a disapproving look. He's looking at the clock. He's looking at both parties. Please tell me the audio is working. Please. I can hear it. Like if I cranked the volume right.
Good morning, everybody. We're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I have both the state and the defense here along with Ms. Benefield. Is there anything we need to talk about, State, before I bring the jury out?
No.
Mr. Taylor?
No, sir.
All right. Are you ready? Are you ready to go? Do you need another minute or are you okay?
I'm ready.
All right.
Thank you.
Well, let's go and bring the jury in.
We will bring the jury.
Jim Gaffigan, the judge, doppelgangers. Thomas says, "That's the look you get from chat when you're tardy." I get that look, the stern librarian glance. This has bothered me the entire trial, Kathy. It really has. And I don't know what to make of it. Because the evidence we're supposed to, take into account for our decision making is what we hear from the stand, not necessarily what we see on the side in court. Jurors entering. It's a performance. It is. But my thing is, I don't know if I would do the same thing.
Can I have a seat? Good morning, everybody. Welcome back. Before we get started, did anybody talk amongst yourselves about the case, discuss it with anyone else, or do any research on it about the case? Nobody says no. All right, when we were finishing up yesterday, the defense had rested its case. The state, if it wishes, can present a rebuttal case. State?
Judge, just very briefly state and call Eva Benefield.
Here we go.
I solemnly swear or affirm the testimony that you give will be the truth, the whole truth, and nothing but the truth.
Ma'am, same rules as last time. Just make yourself comfortable. Get about 12 to 15 inches away from the microphone.
Good morning.
Good morning.
Please state your name.
Eva Benefield.
Okay. And I just have a couple of questions for you. The first is, was your dad right or left-handed?
He was right-handed.
Okay. And I just want to show you a picture. This would be Defense Exhibit 24 that's been entered into evidence of your dad appearing to do a push-up. Have you seen that before?
I have.
Okay. When was that picture taken?
That was taken in 2018.
And then I want to show you State's Exhibit 105. Can you tell me what this is?
That's a picture of my dad on the boat.
And when was this picture taken?
That was August of 2020.
And is this an accurate reflection of the way he looked in August of 2020?
Yes, ma'am.
Okay. Judge, I just want to publish it briefly. Oh, at this time I would enter State's Exhibit 105 into evidence.
Same objections?
No objection.
No objection. Proceed.
There. Okay. Is this the picture 105 that you just identified?
Yes, ma'am.
Okay. Thank you very much. I have no further questions.
You can cross, Mr. Taylor.
No question.
Can the witness be released from her subpoena?
Yes.
Can the
No
witness
questions.
Be released? Can the witness be released from her subpoena?
Yes.
May you released from your subpoena, you're free to go.
Thank you.
Thank you. State.
Now she can
State
talk.
has no further witnesses. Thank you.
All right. All right.
Why was there no questions about the
jury,
dates?
At this point, both sides have rested their cases. That means that the presentation of evidence, testimony, and exhibits has come to a conclusion. If you remember when I gave you those preliminary instructions when we started, I talked about three things: listening to all of the evidence, hearing the argument of counsel, and listening to the law as I instruct you. At this point, we need to take a break so the attorneys and I can sit down, now that everything is done, and work on those jury instructions to make sure they're in final form so that I can instruct you on the law, you can hear those closing arguments, and then we'll release you to go and begin your deliberations. That does take some time. So, and of course, after we're done working here, I want to be able to give the attorneys a break as well to get ready for those closing arguments. So my plan is to, did anybody want to be heard before?
Brief approach. Yeah, there was a zero rebuttal to any of her self-defense claims. I've been giving it some thought, and I want to share a little bit about some things that are going through my head. First of all, I don't know. I don't have the answers. All I can do is speculate here and sort of piece together pieces and what I observe and make guesses. I think it would be a safe bet to say that if you were to point the finger of blame at what was wrong in Ashley and Doug's relationship, that there was fault on both sides, that there could have been manipulation on both sides, there could have been, a lot of finger pointing that could go both directions. A lot of people say, you know, the big thing that sticks out to them is she invited him over. She invited him over to shoot him, and I don't have any testimony that's why she did it. I don't have any evidence that's why she did it. We don't have, you know, how to hide a body, how to shoot people, and get away with it. Google searches.
Give you a break. If I could have you back downstairs at the jury assembly room at 12:30.
Oh my goodness!
And then
all
we're
morning.
going to get you rounded up and get you back up here and get going with. If you remember, it's going to be some initial instructions by me on the law. The attorneys will have a chance to give their closing arguments if they wish. Then there'll be some final instructions, and then you'll begin deliberations. So remember, now that everything is done, please remember the rules. Don't discuss the case amongst yourselves until all of those things are done. Don't talk with anyone else about the case. And please don't do any research or watch any coverage about the case. All right, so we'll see you back downstairs at 12:30. Thank you.
So she did invite him over. There wasn't a history of battering, although there was some violence in the history. My thought was this. How many times would a woman need to fear for her life before she was justified in using lethal force in self-defense? I think that answer has to be one. If somebody you don't know puts you in fear, you have every right to do it. And so
an email from the state with, I haven't had a chance to look at it yet.
So you have a printed copy?
I do. I have print out a copy for me.
State never impeached her. There was nothing she was impeached on. The closest thing was what she told her lawyer. The picture was taken in 2020, and they got testimony it was 2018. But the jury didn't hear her say that.
I assume that this has all of the changes that we discussed yesterday?
Yes, to the best of our ability, yes.
All right. So let's go ahead and take a run through these. And Ms. Benefield, please feel free to share a copy with your attorney, look over his shoulder. So, Mr. Taylor, as we go through these, we'll take our time, just look at them. If you have any objections, additions, corrections, deletions, please voice them. State, even though you prepared them from the standards, if you have any objections, additions, corrections, or deletions, please let me know as we go.
Yes, sir. Thank you.
All right. First, 3.1. Any objection?
No.
3.2, statement of the charge. Any objection?
No.
Mr. Taylor sounds really sick.
Introduction to homicide, justifiable, and excusable.
No objection. You have to the second part. Under great bodily harm, means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I object to that part. I think particularly because of the nature of the facts in this case.
State.
It's a standard jury instruction, Judge. We'd be asked that it be read unedited.
Specifically, Your Honor, because of the unique facts of this case, that is to say, relatively minor bruising leading up to the crescendo of the actual event, I think to keep this instruction as it is to the distinct detriment of Ms. Benefield, because it's basically telling them that they can overlook what precipitated the final incident.
All right. I understand your argument. It is part of the standard jury instruction. It's not misleading in its nature in describing great bodily harm. It complies with Florida law and the statutes. I think it needs to be given as part of the standard instruction. So I'll overrule that objection. Other than that one, the rest of it looked all right?
Yes.
7.4, murder in the second degree.
And it's the state's position that that part in yellow about sudden provocation should come out.
Judge, I'm sorry. I just wanted to also mention in the May update to the jury instructions, they cut out the reference to mere bruises.
Oh, then it's coming out. The judge likes to be current.
No, well, online, it still has on the.
Do you have the Florida Supreme Court order on that?
I'm on the bar website. So
No, defense. Do you have there'd be a Florida Supreme Court order. Do you have that?
I do not have it with me, no, but I believe that it was removed from the May update.
Well, we can check. Let's do a quick Google, shall we? Florida standard jury instructions.
You have it right there.
Great bodily harm.
I may have it, Judge. Give me 1 second.
Yeah, I'm going to have to see it. The Florida Bar website still does not include mere bruising.
Okay, you're a judge.
Yeah. Well, can you show it to the state first?
Well, this is a different instruction, sir. This is not homicide. This is just felony use of deadly force. That's a different instruction. That's the one that was updated in May. Murder, the introduction of homicide was not updated in May.
This is 3.6F, justifiable use of threat and use of deadly force. Or we'll note that mere bruises has been redacted.
Thank you for letting me review that.
Just to make sure we're clear, the old version of self-defense read exactly like the new version. It wasn't taken out in 2024. That was not the parts that were amended.
They're fighting hard because this is a big one for the state if it says this.
All right. Again, I appreciate the argument. It's a standard jury instruction. It's not a misstatement of the law. I'm going to give the standard.
It's big for the state.
7.4.
It's okay.
And Judge, it's the state's position that there's been no evidence of sudden provocation. I'm sorry, heat of passion, unadequate provocation. There was no evidence that a reasonable person would have lost normal control, would have been drunk. There was no evidence of a blind and a reasoning fury, so the state would ask that that section be removed.
Do you want the sudden provocation? towards the bottom of 7.4, going to the second page.
It's the yellow part.
I'm fine with it like it is.
So you want it in?
Yes.
And state you want it out?
It's going in.
I don't think there's been any evidence that entered to go to those facts. That portion.
I would argue that he, according to Ashley, he flipped.
All right, I'll leave it in.
That's good for the defense.
3.3D, possession firearm.
Fine.
State. 3.4, lesser included.
Fine.
7.7, manslaughter.
Fine.
3.3A, aggravation of manslaughter with a firearm.
Acceptable.
All right, 3.6, justifiable use of force.
Yeah. Which one? Yeah, two small tweaks.
I'm sorry, which instruction are we on?
3.6F.
Oh, okay, that's what I thought.
I wonder if the court would consider under the second part giving an instruction on imminent, what imminent means. The instruction as is reads, the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real. We could provide to the court a definition of imminent, but we'd like to have it.
All right, do you have it? Do you have a proposed jury instruction?
I'm not prepared at this point to tender it to the court.
Come on, Mr. Taylor. If you don't bring something, the judge won't do it. It's like
this is the
filing a
final
motion
charge conference, so I'm going
It's
to
like
need
filing
it.
a motion without asking for relief.
Give me a moment, Your Honor.
Yes, sir.
I think they do have time.
Okay, here's one that we had, Judge, in preparation. I'm trying to keep up with all the paperwork. That's the one you now. Your Honor, I'd also like to request, if we could, adding a definition of great bodily harm in the deadly force definition paragraph.
Where did that definition come from? Immediate.
I think it might have come from case law.
It says it comes from Webster's Dictionary. The state objects. Number one, that the definition does not make sense.
This is Judge
to the
White.
State. Number two, I'm on Webster's Dictionary where it says it comes from, and that is not the definition provided by Webster's Dictionary. It's partially, I mean, it's parts of the definition, but the Florida Supreme Court has not felt the need to define imminent. I think imminent is a word that is commonly understood by these jurors, and the state would object to adding that definition or changing the definition of great bodily harm in this 3.6, which I think was his second request, which it's in the second paragraph. Great bodily harm means distinguished from slight, trivial, minor, or moderate harm. That second paragraph.
We're not asking the court to change the definition of great bodily harm. We're just asking Your Honor to add it in that paragraph as well.
In which paragraph?
Under 3.6F, the second paragraph, where it defines deadly force, means force likely to cause death or great bodily harm.
The very next sentence is the definition of great bodily harm.
Well, it's got a definition of great bodily harm.
No, it's not.
And actually, my copy has an explanation.
Right,
That's the standard.
it's from the standard.
Yeah. Okay.
And then it was you asked for imminent, you made your arguments against it, rebuttal.
No rebuttal other than I don't see what the downside is to it. I don't see how there could be any prejudice.
Okay. I appreciate that. I've never given a definition for imminent, and I'm not saying my ruling is based upon, well, I've never done it in the past, why would I do it now? I've separately and independently reviewed your proposed definition of imminent. I don't find imminent to be a word not in common usage or understood by an average juror. I don't think it needs to be defined. It's not defined in the standard. So do you want this marked and put in? Because I don't think you read it in. So let me mark it to preserve. So this is defendant's proposed definition of imminent. See the 30th. All right, that'll be filed.
And Judge, I think we got ahead of ourselves in this instruction. So if we could go back. Under the paragraph on 3.6F, the first page, it says the law and justifiable use of deadly force is as follows. It's the state's opinion that that first section in yellow would come out because of where it says, but is not relying on 776.0131, which this defendant is relying on that portion, which is the very next portion, and is almost identical, other than it adds extra things about since she was in a dwelling.
Well, that's what we discussed late yesterday, so
yes.
You're in agreement?
Okay.
Yeah.
All right. So
I'm sorry, Judge. I didn't realize we made a decision on that.
Well, I don't think we made a decision.
Okay.
I just rambled on and on explaining the difference between the two and the distinctions and why 776.0122 and 776.0312 differed than 776.0131.
He's not wrong.
Covered the same ground. Just one is
rambled on and on.
General self-defense and stand your ground, and the other one is in your home. And I would think that the defense wants the in your home.
Yes, sir. So I think we would pick up after that law on just to if she's in a dwelling, that portion.
Right.
Okay.
All right, here's where we're going to need to take a few moments to talk about the forcible felonies.
These forcible felonies, these are,
I had written them down yesterday.
These are crimes that can be committed or attempted to be committed against you that you can legally use deadly force to prevent.
All right, state yesterday, well, let me confirm with the defense. So on the actual self-defense instruction that we're going to use for the 776.013 subsection 1, I assume that you're going to want A and B?
Yes.
Okay. And then the forcible felonies you mentioned yesterday are burglary, felony bat, ag assault, false imprisonment.
Correct.
Are there any others?
No, sir.
No felony battery. I thought felony. Did you say felony battery?
Mm-hmm.
Okay, I'm sorry.
That's what was requested.
Yes, I missed it when you just said it, Judge. Sorry.
Burglary, ag bat, felony bat, ag assault, false imprisonment. State, are there any of those that you want to agree with before I hear argument from both sides?
No, Judge.
You don't agree with any of them?
Well, I may agree with false imprisonment. I need to think through burglary still. I've been thinking through it for the last 12 hours or 16 hours, but I'm not sure yet on that one. So I just think there's problems with each one of them, and I'd rather if we could just go through them.
Okay. Burglary.
I think it's a classic remaining inside. The testimony, if the court recalls, from Miss Benefield was that when he spun her around in her effort to leave the home and block the door, she summoned the wherewithal to command him to leave now. You have to leave now. That would have revoked his license to be present, and as a result, at that point, he was a remaining inside burglar.
Follow that logic. I'm not sure if this will stick. This might drop off.
All right, well, that's not just the end of it. So I've got the standard instruction for burglary, which would need to be obviously modified.
With the intent.
Because I don't instruct them on the burden of proof. It's just the elements for any of these forcible felonies. The initial portion is going to be the elements of or for the forcible felony of burglary are, and then it'll give the elements. But if you, on the burglary, under 2, there's 2A, B, or C, so I need to know which one of those you're arguing.
A is surreptitiously and with the intent to commit an offense other than burglary or trespass. He entered the structure.
Based upon what you just argued,
after entering,
I'm assuming that you want 2B, as in Bravo.
After permission to remain there had been withdrawn.
That would be essentially 2 would be Doug Benefield, after entering the structure, remained therein after permission to remain had been withdrawn.
Right.
And with the intent to commit, there has to be some crime alleged, right? Because it can't be burglary or trespass.
It has to be one of the other ones.
Or it could just be an offense other than burglary or trespass inside the structure. I need to know what you're proposing.
Give me a moment.
I would leave it an offense other than burglary or trespass. It leaves it wide open instead of trying to nail it down to a specific crime. Because if the jury finds that Doug was not, according to the testimony, committing that crime,
I think we would prefer other than.
Yes. That's the right answer.
All right, State. Now it's. And are you asking for any other portion of the burglary statute if it's to be given?
Give me just a minute, Your Honor.
Burglary statute is, look at this, it's what, 10 pages long? Oh, that's case law, never mind. To prove the crime of burglary, the state must prove the following 2 elements beyond a reasonable doubt. Defendant had permission or consent to enter a structure or conveyance owned by or in possession of the person alleged.
Referencing.
It's 13.1.
And after entering the structure, remained therein for one of 3 reasons. And the second reason was to, after permission to remain had been withdrawn and his intent to commit an offense other than burglary or trespass inside the conveyance.
I think the internet just came back. It was down. Okay.
Jen, did you fix the internet for everybody?
What was the court's question?
On the burglary instruction. So we've nailed down the elements that you're asking for. I'm asking, is there any other portion of that, before I go to the state and get their argument, is there any other portion of 13.1 burglary that you're requesting?
The answer here is no.
Judge, are we talking about, I just want to make sure we're talking about the same thing.
No, so
A, B, or C?
the court is giving 1 and 2 had permission or consent to enter, and 2 after entering remain therein.
Yep, and then I have to give A, B, or C as appropriate. And I'm sorry, that's A, B, or C. Can be
so do you want
in the
A
conjunctive
or C?
or the disjunctive.
All right, we would request B and C, Your Honor.
Let's see what C is really quickly. C is to commit or attempt to commit a forcible felony.
And on C that you're requesting, is it just to commit or attempt to commit a forcible felony?
Yes.
Which potentially will be. Now, any other portion of that instruction before I go to the state?
Meaning, do you want A? The state says that Mr. O'Keefe is practicing law without a license here by consulting and sharing and giving information to Mr. Taylor. They don't like this. The judge allows it.
Or you state, whenever I get over to you, if I do decide to give it, if there's any additional portions, be prepared to argue those.
No, that's it, Your Honor.
All right. Okay, that's it, state. So they want, defense is asking for that. Are you looking at the standard for burglary?
Yes.
So it's on the second page.
Yes, sir.
And if I give it, it'll essentially be something along the lines of the elements of the forcible felony of burglary are 1, 2, B and C. On B, of course, the conveyances would be struck. B would be after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure. C, of course, there'd be an or.
This is confusing because she is not charged with these
or
crimes.
attempt to commit a forcible felony.
They're literally talking about what
So,
Doug
obviously
did
you object to that.
prior
But
to
if I am going to
getting
allow it,
shot.
is there any other part of this instruction that you would want to be given?
2 paragraphs. Oh, let's see. It says the next paragraph is about intent being an operation of the mind. The following paragraph says, even though the unlawful remaining in a structure is proved, and I know we're not supposed to talk about proof, so I don't know how we would word it. If the evidence does not establish that it was done with the intent to commit a crime other than burglary or trespass, the defendant must not be found guilty. I don't know how we would word that because we don't have proof, but I think that is an important
Good news, I have suggestions.
Okay.
All right, so the state, in addition to what you're requesting for the elements, is asking for those next two paragraphs to be given, which explain intent. And I only had, when I say I have suggestions, this comes up in, I don't want to say every self-defense case, but so many of them, I have language that I've used in the past.
Yes, sir.
All right. So here's what I propose it would sound like, and everybody can object because you don't want it, you want it, but you might not like the language, but I've given it before and it works. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case.
That's exactly verbatim the first
Here's
paragraph.
where the changes are because we're not saying proof beyond a reasonable doubt or anything like that. Here's where I've made changes. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. That's what I've said in the past. And it just, it's an accurate, I'll hear your arguments, but I found that it's an accurate statement of the law.
It's very
because
similar
the other
to how
way
it's
is
written.
the defendant must be found not guilty. That's not what we're talking about here.
Because she's not charged with burglary.
So it's just letting them know that what intent is and how that portion of the instruction operates.
Yeah, that's fine with us.
All right. Do you need that, State?
I will need that. And I can say based on the conversations we have, I don't have an objection to the instructions as you've crafted them.
All right.
We'll need to.
So, I'm sorry, and we also need structure because structure is not defined in any of the other instructions. And that's on the very next page.
Structure.
All right, Mr. Taylor, what I've done is I took the standard instruction and have
Structure means any building of any kind, whether temporary or permanent, that has a roof over it and a closed space.
In my own hand as I've read. Do you mind if I give this to the state so they can take it back and make it part of the instructions?
No.
All right, thank
Does
you.
that include the elements portion too?
Yes.
Okay. Sorry, I was trying to do it as you were talking, but I wasn't keeping up.
My penmanship is horrible. I apologize.
So this is super
This is perfect.
confusing
Thank
as
you.
part of the trial. We're going to talk about a lot of
So
crimes
that's what I've
she's not
approved
charged
for
with.
burglary.
We're now talking about things that Doug was doing that would have
Let's talk about
justified
false
her,
imprisonment next.
or Doug may have done, that would have justified her in using deadly force against
And that's
him.
instruction 9.2.
9.2.
Judge, I have one thing before we leave. On the last portion of 3.6F, justifiable use of deadly force, I wanted to ask the court to substitute 2 words in the final section.
I don't think we've gotten there yet.
We've not gotten there yet?
Not to the end of the instruction. We're still doing the forcible felonies portion. Yeah. So the next forcible felony that the defense has requested is false imprisonment. So 9.2, if I give it, again, it'll begin with the elements for the forcible felony of false imprisonment are. So which one of those elements or methods by which one is falsely imprisoned do you think the evidence supports, Mr. Taylor?
Imprisoned or restrained? I don't think
We
we're
would
confined.
like to have
Not abducted.
Confined and restrained.
Not imprisoned.
Just those two?
Yes, sir.
Okay. And also on number 1, it's you would need to read Doug Benefield forcibly, secretly, by threat. Which one of those?
By threat. Or forcibly. Forcibly.
So you're not asking for secretly or by threat. That actually make it easier because secretly has to be defined.
How about forcibly and by threat, Judge?
Well, would be or.
We'll get feeling better. Thanks for
That
being
means
our eyes
we
in
would
this
not
court.
need secretly. All right, state.
The state would object. There is no evidence of the time in which Ms. Benefield used deadly force that Mr. Benefield was preventing her from leaving. If there was a time in which there could be argued a false imprisonment, it would have been when she tried to get out the door and claims that he spun her around by her arm. But there was no evidence that once she was in the bedroom, there was any effort to forcibly or by threat confine or restrain her without her lawful consent, so the state would object.
Rebuttal.
Well, actually, I believe the testimony was that when she turned around, he was standing in the middle of the doorway, blocking the exit to the room.
All right, I understand completely that each side has their own theories and thoughts and not versions of the facts, but view of the facts. However, the facts as presented by the defendant do support the giving of this instruction. False imprisonment, here's how it'll read. The elements for the forcible felony of false imprisonment are Doug Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. Doug Benefield had no lawful authority to do so. That would be the end of that instruction. As I review the rest of it, the rest has to do with certain enhancements.
Are you giving me that one too? Are you going to give me that one too?
I would ask.
If not, I'm going to need you to repeat it.
Yeah, no. Okay. My plan is to, after I do this, give them to you because then it's all.
Yes, sir. Thank you.
I'm sorry to put that on you because I know you're objecting to it, but.
It's on her. It's on her.
All right. Anything else on false imprisonment? So I am going to give it as I just read.
Okay. Yes, we would request a specific definition of the term false imprisonment based on the case law Proco versus State, if I may.
A definition of false imprisonment?
Yes.
The elements are there.
Isn't that the elements of false imprisonment is the definition of it?
What are you asking, Mr. Taylor?
This just lays it out, Your Honor.
Okay. Let me just, go ahead and take a look at it real quick. State.
This seems a little monotonous, but it definitely is a very, very important part of the trial. It sets the ground rules for how the jury is going to deliberate, and how they view the evidence, how they treat the evidence that they've received.
Did you want to be heard on this?
We object. I think the elements are sufficient.
Any further arguments?
No, sir.
All right.
How many objections have I missed? Sorry, guys.
I see where you
got that one.
Pulled case law that defines and explains some of the factual scenarios that have been presented in various cases and whether those meant or equated to or violated the false imprisonment statute.
It's not coming in.
But I don't think I would give a definition of false imprisonment in the false imprisonment instruction. It's false imprisonment, then you explain the elements, and then both sides can certainly argue whether those acts were or were not violative of false imprisonment. Do you want this one, Mark?
Please.
All right, so let me do this. Same thing, it's just my marked up version that I'm going to give them so they can, that way the typeface will all be the same. Thank you.
As soon as she told him to leave, he was no longer welcome in her house.
Instruction.
And at that point, he became a burglar when he remained. So you can invite someone over, and then they decide to commit a crime. You can say, hey, no, not here. And if they stay, that's what they're alleging here. Then when she tried to leave, when he grabbed her hand and pulled her back, according to the testimony.
How about aggravated battery next? I'm trying to take them in some semblance of descending order. Might not be perfect, but all right. Ag bat.
Trying to follow along here. Give 1A or B, but not or both. In this case, the victim actually and intentionally touched or struck.
So I guess what I'm looking for
the defendant.
defense from you is what parts or portions of aggravated battery 8.4 you're asking for. We would start with Doug Benefield, A or B under number 1.
Judge, I think, frankly, after reviewing this instruction, we're going to withdraw the request.
Okay. So ag bat is withdrawn. Next one is felony battery. 8.5.
Doug actually and intentionally struck or touched or struck Ashley against her will, and Doug caused Ashley great bodily harm, permanent disability, or permanent disfigurement. That's going to be a tough one as well.
Yeah, we're going to withdraw that as well.
Yeah.
You're right.
All right, felony battery is withdrawn as a forcible felony. And the final one that you had requested was 8.2, aggravated assault.
Aggravated assault. It's a big one. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. Doug intentionally and unlawfully threatened, either by word or by act, to do violence. I think they can go with that one. At the time, Doug appeared to have the ability to carry out the threat.
Everybody check your phones. Make sure they're on silent or turned off.
This one, I think, is viable.
You want to keep?
Yes, sir.
All right.
Part 3, the acts of Doug created in the mind of
Ashley. There are
Ashley.
some options, so let me go through them.
Well-founded fear that violence was about to take
one
place.
Is standard, 2 is standard, 3 is standard, but then under 4, are you asking for A or B?
B.
B.
The assault was made with a fully formed conscious intent to
And
commit
what is the
crime?
Felony charged? The assault was made with a fully formed conscious intent to commit.
I think false imprisonment, Your Honor. Give me just a moment. I'm considering whether it would also establish any of the others.
You can't have the assault made with the intent to commit aggravated assault. It has to be a different.
False imprisonment, Your Honor.
Sir?
False imprisonment.
Okay.
It's the same argument. Well, it's a 2-part argument, Judge. It's the same argument as to false imprisonment. I know you already were getting it, they're getting it, but I don't think that there's evidence that he made threats by word or act, I guess, other than "you're done," which the state would argue is ambiguous. At the time, the defendant Mr. Benefield appeared to have carried out the threat. I don't know what that means for this case, and the defendant created a well-founded fear of violence was about to take place. I mean, I think this is so akin to the self-defense argument that I think it's duplicative, but also to then say that assault was made with a fully formed conscious intent to commit false imprisonment against her. Their argument was just that he was already false imprisoning her when I don't know how you would put this in there, Judge, because he was already committing a false imprisonment, and then when he made the threat, he was then fully informed to commit another false imprisonment. I just think it's circular, and I'm not sure that it will make sense for the jury. I think it'll be confusing.
Like like most of these things, it becomes a question of fact for the jury. And I'm not prepared to say precisely when, given those facts and the fluidness of the circumstances, when or for that matter, if the jury will conclude that there was a false imprisonment.
All right, thank you both very much. I'll give it. The question is, any other portions of that, or it's just the elements of that one? Certainly there's no deadly weapon.
I think the first one, if the circumstances were such, that should be in. Deadly weapon is out.
What about if 4A
as
is
would
alleged?
be an object not designed to inflict bodily harm.
That's all. There's nothing else.
Great bodily harm is out.
That's all. We're done with that one.
As would be, Judge, not necessary that the defendant had an intent to kill.
Okay, you give this one to the state. So that'll be the last one. Those are. So we ended up with 2, right? 3.
And I guess, Judge, I'm going to need some guidance on how to word this. Imminent commission of forcible or burglary, comma, false imprisonment. Like that sentence isn't going to make sense.
I'll give that to you.
Thank you.
All right, so I think it would need to say imminent death or great bodily harm to herself, or the imminent commission of burglary, false imprisonment, or aggravated assault against herself. It'd be in the disjunctive. And then immediately after that, I'll need
Those in order.
yes.
Yes.
Thank you. All right, the next portion of what we need to discuss on the self-defense, we're still on 3.6F. We're through the use of force in the home. The very next paragraph talks about 782.02. This is the bottom of the second page of the state's, I think it's on the bottom of the second page.
I thought I took it out.
I think we talked about yesterday removing that, but let me make sure. The portion about 782.02.
I think I already took it out, though.
I thought we did, but I have a question mark next to the one on my copy.
Oh, okay.
So I'm just making sure.
I have the next, the next paragraph I have after the ones we were just discussing is in deciding whether Ashley Benefield was justified. Is the next paragraph I have on the one we did last night. Is that what you showed, Judge?
I look at the wrong.
I had thought you had asked yesterday if we wanted A and B, and we said yes.
That's how we're talking about.
On which one? I'm talking about the portion that was 782.02. And like the state said, I have it, we weren't going to give it, but then I have a question mark by it, so that makes me wonder if it was, we're not going to give it, but we're going to think about it.
While they're talking, I want to show off the amazing thumbnail we have as they're working here. Oops, I'll keep the audio going.
Again, I think that's what it is, but this could be just me having a question mark there for, I don't know why.
We've got the judge up here with the scissors.
But I just want to get confirmation on the record that we're not giving it.
Oh my goodness. There's so much on here that's just hilarious. I do see the upside down pineapple in there. Page 2, if you look on this, has all the instructions and who added what. Lots of fun stuff on the thumbnail.
C. Yeah, we'd like to have a judge, and we would request B and C.
All right, any further argument?
No, Your Honor.
No.
In response to the court's question, did I have any further argument?
Okay. So, before I go to the state, because this is my question, if we're giving 776013 that talks about the approved or justified use of deadly force when one is in their own home or in their own residence or dwelling house, including, and I'm going to give to prevent the imminent death or great bodily harm to herself, the imminent commission of those forcible felonies that I'm allowing, what are we gaining by adding 782.02? It seems duplicative to me.
It wouldn't be the first time that there's an instruction that overlaps.
All right. State, you want to be heard?
Yes, Judge. It's not an instruction that overlaps. It's repeating parts that are already in the instructions. The first paragraph is in 7.1, justifiable homicide, that almost the exact paragraph. And I believe the state's contention would be these are cases that are not when there's been a homicide, so you wouldn't have read 7.1. That's why it would be in self-defense when you use deadly force, but it's not necessarily homicide. And I think that to say B and C, that is exactly what you've already just read. And I do think it's duplicative, and I think could be confusing, and we don't.
All right, final thoughts.
Nothing further.
He's not arguing. He needs to argue. This is going to come out.
I think I've shown that I tend to give instructions when they're lawful, they're an accurate statement of the law. The facts of the case support the giving of the instruction, and it's necessary to explain or clarify an area of the law to the jury so that they can do their job. However, when you look at what's being proposed under 782.02, that portion of the instruction, it is, while a different order, it's virtually identical. Subsection C talks about the commission of a felony upon Ashley Benefield in a dwelling house in which she was present, and that is taken care of in the instruction we're giving from 776.0131. It starts, if Ashley Benefield was in a dwelling or residence in which she had a right to be, and then she is justified to use that deadly force to prevent the imminent commission of a forcible felony. So C is taken care of in what we're already given. And so is B, because it talks about committing a felony upon her, but doesn't talk about the dwelling house. So, quite frankly, we're already giving that. That wouldn't just be duplicative, it would be the exact same instruction being given twice. The 776.013 subsection 1 covers all of the issues and elements that have been presented. All right, the next one is then in deciding whether Ashley Benefield was justified. Certainly that's in.
Yes, sir.
So why do they have it in the standard as two different things? The standard has both. It has 776.013, immediately followed by 782.02.
And then we discussed yesterday, all of that middle part is out. And then the last portion.
Yeah, Judge.
Yes.
They've added, if I'm not mistaken, they've added totality of circumstances to that paragraph.
Which paragraph?
In deciding whether Ashley Benefield is justified in the use of deadly force, you must consider the totality of the circumstances.
It says you must consider the circumstances at the time the force was
They've
used.
struck by which he or she was surrounded. So totality of circumstances at the time.
Sorry, do you have that where it was?
Yeah.
Page 4.
If you just throw that to the state first.
Those are proposed. That is not what happened. What's online is what happened. Those are proposals.
We didn't strike it. If you look at 3.6 as the Florida Bar has it, it's the same. That's the proposals to the subcommittee.
So we would like the proposed language.
Okay. Oh, so is that just a memo that you wrote?
It's the commission. It was when they proposed instructions before they finalized.
This was from the committee.
So the committee proposed putting in totality of the circumstances,
Correct.
but it wasn't adopted.
Correct.
Okay, I got you.
We would object.
As the court knows, the court's not married to the patterns any longer.
All right. Thank you very much for the argument. I think the standard jury instruction that we're dealing with adequately explains the law. It's not a misstatement. It's not going to mislead the jury in any way. So I'm not going to add totality of the circumstances. The jury is told you must consider the circumstances at the time the force was used. So I think it's sufficient. So that remains.
Totality would have been very good for defense.
If you look, then all that middle part is out, and then it goes to if you find that Ashley Benefield, who because of prior threats or difficulties had reasonable grounds to believe. Do you see that part?
I already took it out on the version I did last night, Judge, so it might be. I think he's working off the state's newer version. I took out everything you had already said.
Right, all that middle part is out. So it's going to go from you must, look at the circumstances that she was faced with, and then it has the part about you may consider and you should consider those prior threats and acts of violence that she knew about or was aware of.
If you find that Ashley, because of prior threats or difficulties with Doug.
Paragraph.
Yes, sir.
Rather than committed an act of violence, we would request that it read had committed acts of violence. You may consider rather than that, this. based on the evidence, there's obviously more than one act.
Ashley had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Doug.
As you said, the penultimate paragraph, the next to last paragraph, and it says Doug Benefield had committed an act of violence. They want it to be acts of violence.
Oh, it does say or acts of violence on the standard, so we have no objection. I'll change it.
All right. Well, so do you want it to say an act or acts, or just committed acts?
Acts, A-C-T-S, acts of violence, and you may consider this rather than that.
It's that fact in determining.
You wanted to say this fact instead of that fact?
Correct.
Okay. I don't know.
Plural as opposed to
I would say these facts.
Sure.
That's fine, Judge.
All right. Anything else on 3.6F?
No.
State?
No.
Okay.
Thank you.
3.7. Any objection?
3.7 is plea of not guilty, reasonable doubt, the burden of proof.
Sir, you're not writing down each sniffle, are you?
No snuffle.
Okay, thank you.
It's a lot. Have to make a new one.
Defendant has entered a plea of not guilty. This means he must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant's charge was committed, and the defendant is the person who committed the crime.
Missing on this one, proof beyond a reasonable doubt does not mean proof beyond all doubt.
Where is that at?
It's in the middle of the page.
It would come right before a reasonable doubt is not a mere possible doubt.
This is standard instruction. That should be on there. Good catch, Mr. Taylor. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt.
3.7.
Which paragraph are you on? I'm sorry. Oh, okay. I found it.
5. The fifth bolded paragraph.
Oh, that's an update since 2024. There is an update.
Is that the only update?
Yes, that's the only request that I have as to that instruction.
Well, looking at that one, they've also added, is this one of the ones that just came out in May or July?
Obviously, our system has not been updated.
So if you look at the standard, are you on the Florida Supreme Court website? Is that what you guys are looking at too?
I am.
It also has an addition. See, right in the about a third of the way down, the defendant is not required to present evidence or prove anything, which is what we've always had,
right,
except for the defense of affirmative defense to the crime of relevant crime, as I previously explained to you.
I think that can apply.
Do you want to make an argument for or against defense?
Standard. I think that should be in.
Judge, would you mind if I printed while you're talking so that I can correct it for her?
Of course.
Okay. I just didn't want to be rude.
Yeah.
Of course I would mind.
Yeah, so, it's interesting, Judge, because self-defense is an affirmative defense, but yet in the instruction they don't acknowledge that. They just limit the instruction, or as a suggestion, insanity, reunification of an attempt, or rather renunciation of an attempt. No, I think that's confusing. I wouldn't request that.
This is interesting. I'm not even aware of any case law interpreting this addition yet. Because it's interesting, in state, I'm just going to throw this out there. So certainly it's an accurate statement of the law. I think we can all agree on that, right? State has to prove beyond a well, first it's a prima facie case, but proof beyond a reasonable doubt. Then there's the preponderance of the evidence that an affirmative defense, and the defendant has the burden of production and persuasion on it, but then the burden shifts back for the state to prove beyond a reasonable doubt the defendant did not act in. So it's interesting because this addition
does not talk about
says
the second
defendant not required to present evidence or prove anything except for the defense of, but then doesn't talk about that burden shifting.
It would be confusing.
I wasn't on the committee. I'm on a different committee, so I don't know how they. I mean, I understand explaining. Well, the defendant does have some burden, but then not telling them that it's a preponderance of the evidence, more likely than not, greater weight of the evidence, whatever words they wanted to use. But then the burden shifts back to the state to prove beyond a reasonable doubt the defendant's not entitled. So, do you want to be heard?
Yes, I think that we're asking for it. I think insanity and renunciation of attempt are examples. It says e.g. So I think it's well established that self-defense is an affirmative defense, and I don't know what legally would prevent it from being included in this instruction. And I think it is, as Your Honor has already said, an accurate statement of law. So we are asking for that paragraph to be included.
Not that this isn't difficult enough, but if the court does decide to add that, I think the court, in fairness, would be required to elaborate
on the burden shifting,
back to the state, as the court just acknowledged.
All right. Thank you both very much. Here's, and certainly, whenever after I read the instructions and I charge the jury, I'll obviously ask if you have any objections to how the jury was charged. If it's just all the same previous objections, just renew your objections. Here's the reason I hesitate to give this right now. It's brand new, and I could be wrong, but I do have some concerns about how truncated it is with the actual nuances of the burden shifting that goes along with affirmative defenses and not explaining that. So I would feel some compunction if I were going to give this new portion of this instruction to explain that. At the end of the day, though, and remember, where am I getting to? So I could take that path with this new instruction, but going this way with just giving the instruction how it's always been, at the end of the day, the jury still has to find that the state has proven beyond a reasonable doubt the defendant's guilt, and proven beyond a reasonable doubt the defendant is not entitled to. So I appreciate everybody's arguments. I could be wrong, and I'll let somebody else get the case law on how this instruction is going to work now.
Judge doesn't want to be a trendsetter on this one.
I'm going to leave it at the defendant is not required to present evidence or prove anything. You added in that additional sentence, proof beyond a reasonable doubt does not mean beyond all doubt.
Oh, I'm sorry, Chris. So you're going to put a period after the defendant is not required to present evidence, or you're just putting a period there and leaving the rest out?
Yes, leave the standard that is the standard in my mind.
Yes, sir.
And then you added in that sentence at the beginning of the...
I printed out a new one for her, yes.
Any other changes?
No, sir.
I want to hear the definition about the burden shifting.
3.7 good?
No, nothing else.
Except for the objections about...
Yes.
Yeah. That'll be interesting to see how that plays out. All right, 3.9.
No objection.
Perfect. Again, that's where I'm going to stop and then explain to the jury the verdict form. Any objection to 3.10?
No.
3.9 is weighing the evidence. 3.10 was rules for deliberation. 3.11 is cautionary instruction. 3.12 is the verdict.
No.
3.13.
That is submitting the case to the jury. There was nothing
during
in
that
here.
same paragraph I talked. I'm so sorry. That same paragraph about during the trial, items were received, they'll be sent back. I do ad lib at that point because we have a tech cart that's right out here in the hallway. And when they go back to deliberate, they can play the. Is it just the 911 call? Is that the only thing that's in?
Well, but there is a DVD of text messages if they want to read them.
They have a computer back there that has no access to the internet. It's just a laptop that is on the tech cart that they can use to view items or listen to items. So I do go off script there to tell them that. Also, up a couple of paragraphs from there, when I talk about the cell phones have to be, and electronic devices have to be left out. I also talk about smartwatches that can independently and separately communicate with the internet outside of Bluetoothing with another device, and that they have to leave their smartwatches with the.
Sorry, let me give you the link that I was looking at this whole time. So that would have been helpful.
All right, and then
if you
the
guys
verdict
wanted to
form.
follow along. That should get you there. Look at the Florida bar, the rules.
No objection.
On the manslaughter, I thought the manslaughter was just.
We were just talking about that.
Yeah, I think the manslaughter might need to be.
Sometimes
It's just one question, right?
Well, yeah.
There was no
You
instruction.
mean breaking the questions up? I think the state, this is the
About
jury instruction
self-defense.
we've been using because I think that it is confusing I think it puts too much emphasis on the separate charges if you break them up. And I think if they checked manslaughter and then 1, 2, and 3, there's no harm. We just ignore 2 and 3.
All right. Do you want to be heard on that? Because the factual findings are different between, obviously, the second-degree murder and the manslaughter for the sentencing enhancements and the 10-20 life.
Yeah, I don't have a problem.
You're okay with this one? All right, there we go. Not a problem if nobody objects. Well, if there's nothing else, then I'm going to let you all go. It's right about 10:30, so that'll give you 2 full hours. If you could, though, be back, maybe 12:25, 12:20, 12:25, so we can get the courtroom all set. Everybody can be ready to go. I can get the jury up here, and we can get started.
Is there going to be a long J-way argument? And if so, when do we want to do that?
Did you want to make one now, or do you want to wait until the after we let the jury go?
There shouldn't be a long one.
Yeah, do let the jury go.
All right. So the reserve on that.
We get a break. So we are good
All right,
till
y'all. We'll see you back in a little bit.
Thank you.
we're breaking for a couple hours. We can do some court hopping. Okay, audio's off. They're gonna be back just before lunch. 2-hour break. Good news. I shared, this is completely out of the blue, but I shared this previously. A truck hit the telephone pole outside my house. There's like a pole on our property in the corner, and it's the one that our internet goes through. They're replacing the pole right now because the pole is literally broken and it's just sitting on top of itself. It's just like the top part's just swinging, hanging there by the cables. It's been like that for weeks. They're going to replace the pole. My internet, my fiber, it's a single strand of fiber. It might be a double strand of fiber goes through that over that line, and I need it not to be broken as they take everything down and put it back up. Fingers crossed. Fingers crossed. That would be terrible if they break this one. So because then they'd have to rerun the fiber. Let's see. Do we need to start a Starlink fund? Starlink's not fast enough for me. Starlink is like a sixth of the speed that I get from fiber. But all right, I might go set up a camera. And have it pointed at the repair guys. You know what? I could do that. I could set up a camera. Keep an eye on them from in here. I might even be able to use my pan tilt zoom remotely and control it in here and be able to follow, and then you could all watch the repair. Then if the internet goes down, we'll be able to see the exact moment. Well, right when they broke it. My Starlink was much faster than what my fiber was. I pay for 2 gigabit symmetrical, and that's the big thing for me. I push a lot of data up and not just download. A lot of people have a fast download, but I need fast upload and download, and that's why the fiber was better for me. Fiber is laser. You really can't get much faster than light. I'll set up the cat cam. All right, let me just say this. I did not hear anywhere in the jury instructions the jury receive any information about in a self-defense case where the defendant has asserted a self-defense, which she did. It was an affirmative defense, that the burden shifts back to the state to prove it wasn't self-defense. It was not in there. Can't we all use a little extra fiber? Jennifer, that's awesome. Yeah, we'll get a fiber cam set up, but that means we have to do a little break. Let's do a little break here. We'll be back. It's early for lunch. But we'll be back in a little bit. Let's see if I can set up a camera because I want to film this as it goes up or down or both. So, I've not seen Scott Peterson covered by video yet. It's a long wait. They literally blocked off half a mile of street around my house, fearing that this pole would just fall over. And when it didn't, they're like, "Oh, we'll leave it then." And we've had like storms come through, and it's swaying up there. It's terrible. All right, let's do a quick break. I will try to set up this camera if I can get it working properly with remote control. We'll do that. 1G's fast. Funny thing, I've got 2G fiber, but one of my switches is only 1G. So anything beyond that switch on my network only gets half the speed. All right, thank you very much. We are ready for closing arguments, which were made to the jury as soon as we come back in about 2 hours. We'll be back a little bit before then. But we'll be back before that starts. We're going to catch everything that happens in the Ashley Benefield trial. Jury will be deliberating today, and they may even reach a verdict today. We'll see how this goes. Tonight when you go home, please hug the people you love. Smile at someone. Make that day just a little bit better, and please stay safe till we go live. We'll be live probably within an hour. Can we give you that? Within an hour. All right, I've got a camera to set up. You guys, have a good one. We'll see you.